that can't occur. But maybe the introduction or application of the priority provisions can be deferred a bit longer. So I suspect we might see parts of the new regime introduced and parts of it deferred to allow parties to comply. One of the questions that's come up in the Eastern Seaboard in my trips down from Brisbane and Sydney is aircraft. Now, I haven't covered aircraft specifically in the book, but it's a very good paradigm example of the new regime. And in addressing that question, I've been forced to consider a hierarchy of priority interests. And it goes something like this, but you've got to understand, I guess, aircraft financing. Australian companies often buy aircraft abroad, and they get an investment allowance and a depreciation allowance, and then they on-lease the aircraft to other airlines, and they get lease payments. And then they have to finance spare parts and so on, and inventory. Now let's look at what that scenario entails. We have an aircraft with a serial number. We have an aircraft engine with a serial number, so they're both serially numbered goods. We have the rest of the aircraft componentry, which is equipment or other goods. We might have some spare parts, which is equipment. We might have all other forms of intellectual property, like trademarks on the aircraft and so on. We have a revenue stream from the lease repayments on the leased aircraft. They might have assigned the right to receive the lease repayments to a third party, a factor, in order to get cash flow now. And there we have an account receivable. So what is the priority in that situation? Well, on my reading of it, the first ranking priority is the factor, the person who has taken an assignment of the accounts receivable, the rental income. The second ranking priority interest is a purchase money security interest, someone who has, for example, lent money to the airline to acquire new landing gear or new avionics, a new radar system or navigation system, specifically for that purpose. They rank second. The third ranking party would be a party who has perfected their security interest by control, because that's the best form of perfection you can get. And then the next rank would be other secured parties who have perfected their security interest either by registration or possession. And there are special rules for determining who among that group gets priority. And then if you haven't perfected any security interests, your priority is determined by the time of attachment. So in an update, I'm going to compile this hierarchy with the chapter and verse as an illustration, because it's helped me at least find my way through the priority provisions. And if you try to read the priority provisions cold, I don't think you'll find your way through the maze. I certainly wouldn't. So I'm going to try and provide keys to that. We have in the service, or we will have in the first update, a navigational table in which certain items of property are mentioned, and then you've got sections and subject matter. So you might have chattel paper, and you've got section, definition, section, deemed security interest, and so on. So use that if you're using the hard copy version. In the electronic version, of course, you have search boxes and a search engine that can produce that effect electronically, instantaneously. The electronic version, I have to say, looks very good. Just one warning about it. There's a box there called provision. And if you enter a section number in that provision box, it won't bring anything up at present. And that's deliberate, because it's a bill, not an act. When it's an act and you enter the section number, it will bring up the relevant paragraphs and the section, incidentally, relating to that number. But it doesn't do it at present. So I recommend, if you've got the electronic version, use the top box, the first box, as your search strategy. And it's only just come out, so I was working with it in Sydney, and everything I wanted to do was coming up quite easily. Don't worry about the other boxes. Well, you might be. I just use the top box. It's the key. Okay, any questions or comments? I might say that if you subscribe to this service, and frankly, if you work in the area, you must. It's the only thing. If you can't afford the service, go to PPS Downloads and look at how much material there is on PPS Downloads. It will take you weeks to read the material on PPS Downloads and synthesise it. And even then you won't have the Canadian case law or the New Zealand case law. this book has those PPS downloads synthesised and all the Canadian case law that's relevant and New Zealand case law. So it will save you weeks of time, I hope. And that's just the start. Justice Lindgren was kind enough to describe the book as a treatise. I'm the first to admit it's not a treatise, but it will be. I assure you. I'm quite committed to this program. It will be, hopefully, like our other publications that we do together with Thomson Reuters. And over time, it will become a treatise. But we don't have the regulations yet. We haven't got any case law yet. We haven't even got a government decision on various matters yet. When that starts evolving, that will be included. And your first year's subscription will cover all developments for the first year free. So that's important to mind. So there's no point in delaying if you're thinking of getting the service or your firm is. Don't delay. Try to get in now and appreciate the developments as they break. And we will add the new material as it develops. There's a table in the service, at the front of the service, of affected acts. It goes for pages. All those acts are going to be cancelled, repealed, affected at least in some way. Shipping Registration Act will be affected, not repealed. You look for ownership of ships under the Shipping Registration Act, but you look for securities under PPSA. So you'll be able to live together. Uniform Commercial Credit Code will live side by side. So it will be affected, but not necessarily repealed. But some acts, that section of the Corporations Act will be repealed. Some other sections of the Corporations Act will have to be adapted because they refer to floating charges. And that terminology will cease to exist. So there are going to have to be lots of changes. Not necessarily repeals, but that division, yes, will be repealed. Let me leave you with a comment from Jacob Ziegel. Jacob Ziegel is the father of the personal property securities regime in Canada. He started all the regimes in Canada. They've been there for 25 years. That's why it's produced voluminous case law. And he once said that the PPSA regime doesn't solve all the problems, it just creates more interesting ones. And I'm sure you'll find that, but we have to embrace them. We have to embrace the regime. It's not 1992 anymore, it's coming. And the only question is, are we there yet? And we're not quite there yet, but we will be soon. In this new regime, they can invoke the land enforcement provisions. Now this means that the secured party can sell land and personal property in the one sale using the land law of the state or territory where the land is situated. You might have a bus company that has a depot in Tweed Heads in New South Wales, and it operates tour buses throughout the Northern Rivers District of New South Wales and South East Queensland. And a secured party wants to sell the whole business. Well, that's a problem at present. But under these land enforcement provisions, it can sell the land and the bus company and the workshop and all the buses and everything else, the whole box and dice, in one transaction, using the same procedure that you use for selling land in New South Wales. The same notices and so on, the same duties and so on. And that may be a benefit. I don't think it'll be a big deal, but I'm told it is. But I can't see that it's a big deal because you just put in a receiver and the receiver would do it. But anyway, because they'd use the powers under the Corporations Act. But apparently it's a big deal if you don't want to put in a receiver. There's a new garnishee procedure.